welcome to the latest in the series of DMH Stallard Employment Law podcasts. I'm very pleased this morning that I'm joined by my partner, Greg Burgess, and we're looking today at without prejudice conversations, and particularly protected conversations in the employment law context. So just to start off, Greg, can you perhaps recap when and why an employer might want to have a without prejudice conversation with an employee?
Morning. Yeah, in all sorts of different situations, we find them used. Just to recap, the without prejudice principle has been in place for many years. It's a common law principle, and it allows parties in a dispute to have a conversation to try and resolve that dispute in circumstances where that conversation isn't then later admissible as part of a hearing or a tribunal case. In the employment context, we see without prejudice conversations and protected conversations come up all the time. It might be that there's a grievance in play, a breakdown in relationship. There might be performance issues, a redundancy situation. Could be a misconduct where the employer's not sure whether there's quite enough to justify a summary dismissal. And we see them come up where you've got people on long-term sick and employers try and negotiate exits in all sorts of different scenarios like that.
And were you staying without prejudice for a moment before we get on to protected conversations? You said there where there's a pre-existing dispute, without prejudice can be used. What does that dispute need to relate to for the without prejudice tag to apply? So I suppose I'm thinking that you could have a dispute, couldn't you, where perhaps the employee is claiming they haven't been paid properly. But the dispute might not be about termination of employment. Is there something in there that employers just need to bear in mind?
Yeah, I mean, what the case law says on the without prejudice side is that just having, for example, a grievance in play doesn't necessarily mean that the parties are in active dispute, if you like. And so what's evolved over the years is this conflict in the case law as to whether or not there actually is a dispute, because if there is, then the without prejudice rule may apply. But if there's a concern about a pay issue, let's say by an employee, the employer may say, well, that's not a dispute as such, and therefore the without prejudice rule at common law will not necessarily apply.
Yeah, I think that's right. And I think there's also, isn't there, this issue that the dispute might only be about pay, and sometimes an employer might jump in and try and use without prejudice to then effect an exit of the employee. I think there's always that point that the dispute needs to be, or the resolution of the dispute, potential resolution, needs to be about the dispute rather than about something else. I guess that's right. That's the thing. So moving on then to protected conversation. How is that different, and why was it introduced?
So we've had it in play now for about 12 years. So in 2013, the government introduced this statutory framework. So away from the common law, the statutory framework for protected conversations. Why was it introduced? Well, it was to cover these various scenarios where there's not actually a dispute, an active dispute between the employer and the employee yet. There may be in the future, but to allow the parties to have a framework within which they can have a conversation to explore one option, which would be an agreed exit under a settlement agreement. And so the government introduced this framework, which is backed up by a code of practice to allow parties to have what we call protected conversations. In terms of the legislation, it went into the Employment Rights Act 1996, which, as many of us will know, is the main framework for unfair dismissal law in the UK.
Thank you. And does the employee need to agree to have a protected conversation?
Strictly speaking, they should, and the employer shouldn't force it upon them. The way it happens in practice, in my experience, is that the employer will say this is a preferred route for us, and then they put forward the proposed settlement, and the employee goes away and considers it. It's fairly rare in my experience for the employee to turn around and later challenge that, because once the idea of an exit and a package has been put on the table, the employee's focus typically, in my experience, turns to how much they're going to get.
Okay. And but if the employee says, no, I don't want the protected conversation, and the employer sort of tries to sort of force that through, what's the outcome of that?
Well, it could be that is found to be what's called improper behaviour. So under the statutory framework, if the employer typically, but if one of the parties has what's called improper behaviour, they put too much pressure on the other party in the without prejudice and protected conversation, then that can be evidence to put before a tribunal to say that the content of that conversation is not protected and therefore could be admissible in evidence in any later tribunal proceedings. So the employers need to tread carefully. In my experience, I must say, I think employers are pretty good at positioning it in the right way. And when I'm advising employers about this, I would say to them is that, put the offer to the individual. If you get any sense of, resistance to the idea of having a protected conversation, then backtrack and then go to your plan B, which might be a performance conversation, or it might be let the grievance carry on, or whatever it might be.
Okay, thank you. And I guess just sort of emphasising or highlighting, why might an employee tactically want to challenge the status of a conversation that the employer says, well, that's a protected conversation, and the employee wants to argue that it isn't?
Well, if they do decide to litigate, it could be important and persuasive evidence as part of a tribunal claim. So if they want to rely on what's been said in a protected conversation, then to support, let's say, an unfair dismissal claim or a discrimination claim, then they would argue that it wasn't truly protected. They might want to show that it's part of this heavy-handed tactics that their horrible employer has deployed on them. Or it might be, for example, let's say it's a redundancy case. They might want to use it as evidence to show that actually the redundancy was a sham. It was a fait accompli, that they were always going to be the person that was selected for redundancy. So they can use it to their tactical advantage if it went to tribunal, if they can persuade a tribunal that the protected conversation protection doesn't apply.
Yeah, and I guess one aspect there is probably being very clear, isn't it, to the employee that the protected conversation and the sort of elegant exit, whilst that might be the preferred outcome, is not the only outcome, or that the process that otherwise formal process might follow isn't a foregone conclusion. You were saying that in relation to redundancy.
Exactly. Yeah, no, exactly right.
Okay. We touched then on the sort of things that the employer might do. So the employer needs perhaps to be careful not to give that impression of the foregone conclusion. But there are other steps that the employer might take to reduce the risk of challenge, or particularly successful challenge against it being a protected conversation.
Yeah. So in terms of steps, there is a structure that employers should use. They should be mindful of the ACAS Code of Practice. What are the key aspects of that? Well, they need to make sure that they allow the person to be accompanied. That's one of the things set out in the code. Another interesting aspect of the code, which I must admit in my experience isn't always followed, is the fact that an employer should give the employee a reasonable amount of time to consider an offer, and their guidance is that they should be given 10 days. Now, in my experience, I must admit, employers often want to move at pace with these things, and I would say it is fairly common for a deal to be done quickly, but certainly at the outset, the employer should be giving the employee time to consider the offer, to go off and take independent legal advice, and 10 days is the guidance that they should have in mind.
Yes, so Greg, absolutely. So on that 10-day point, I think there's a little bit of uncertainty or lack of clarity about whether the 10 days is to consider the offer, perhaps the headline terms, or whether it's to consider the formal settlement agreement, obviously, which would normally follow as part of that process, or whether it's 10 days for the whole lot. And certainly seen cases where that point gets argued by the
Yeah,
employee's representative.
yeah. And what happens in my experience when employers come to us is they want to explore the option of a settlement, but they don't want things to drag on, because if the settlement isn't going to be agreed, then they want to get on with whatever process as quickly as they can to keep that pressure on the employee. So it's quite interesting in practice, because I do see it very often that they give them a few days to consider, and in many cases, because it does unfortunately come down to money, a deal can be done, and very often inside that 10 days.
Are there any particular downsides to the code for employers, would you say?
Well, just on that point about that timing, is that it can take time. If you do stick to the 10 days, and let's say it can then drag on, tactically employees sometimes do drag these things out, because they think, well, I'll extend my termination date, I'll carry on getting paid, and I'll let these negotiations run into week 3 and week 4, which is why employers are pretty sharp to make sure that there's pace on the negotiations, and if the terms aren't agreed within certain period of time, then they resort to that plan B. They start the formal performance process. The other downside, significant downside, is that if there's discrimination or whistleblowing in play, then they don't have the protection necessarily of Section 111A, the protected conversation protection. So a typical example would be someone who's been off sick, let's say been off sick for some time. Let's assume that they've got disability protection, in which case, whilst an employer will want to try and have that conversation, and they might frame it as a protected conversation, because discrimination may be in play, then the Section 111A, the protected conversation protection, doesn't necessarily apply, because it doesn't apply in circumstances where there's a potential discrimination or a whistleblowing type claim.
Okay. No, thank you. That's pretty helpful. I think it's a very important point, in that the employer perhaps, of course, may argue that the individual isn't disabled, but the employee, of course, says, or the employee's advisor in due course may well raise it, and so it puts the employer to some degree at risk on that.
Exactly.
Are there any steps you think particularly that employers can take to mitigate the sort of some of the risks that we're identifying?
Well, it's all about judgment. All these things are always about judgment, and that's why often employer clients will come to us to help them with that judgment, to manage their risk. So I always will talk to a client about the individual to find out what the circumstances are, what the nature of the individual is. Are they a genuine litigation risk, or are they someone who is going to be fairly accommodating or understanding, not too aggressive in terms of negotiations? And if you are presenting the option of a protected conversation as just one option in the circumstances, then that can help mitigate the risk, because if you present it as one option, you explore it, and either a deal will be done or it won't. If it's not done, provided that you have followed the code and as we set out in terms of the steps, then they can mitigate their risk in that way.
So the only starting risk probably there is maybe the 10 days, 14 days, whatever, to see whether or not the protected conversation is going to bear fruit. But otherwise, you go back to plan A, which might be the process, but of course, which itself, particularly if it's a performance process or a sickness management, might well take some time.
That's right, exactly.
Okay. And are there any particular sort of pitfalls that employers fall into, or common mistakes that you see?
Well, I must admit, in the 12 years that we've had protected conversations, I haven't had a tribunal claim where an employee has successfully persuaded a tribunal that there wasn't a truly protected conversation. So I must admit, I do take the view, based on experience, that the risks to employers of things going wrong in a protected conversation are manageable and are probably quite low. So I don't really see employers getting it wrong. The only question is whether they are prepared to show that flexibility or whether they are determined to push this through as the only option and to effectively force the employee to consider an offer that's made. Unfortunately, as crude as it sounds, and as I've indicated, these things do come down to money ultimately. And even when an employee presents himself as entirely affronted that their employer has suggested an exit, if the money's right or the negotiation gets to a point where the money's right, in my experience, 9 times out of 10, a deal can get done. And so the employer can get the resolution, if you like, that they are relatively comfortable with.
Is the other bit, I think I sort of broadly agree with that in terms of experience. Of course, it's that 9th or 10th case which then goes sort of all horribly wrong. But I think it's that fundamental point about this is an option and it remains an option for an employee. And I think as long as the employer isn't saying it is the only option, and basically you've got to leave, or the outcome of any process is a foregone conclusion, I think that's probably the key thing, as you say there, Greg. But in terms of using protected conversations, are they used, do you think, within the statutory framework intended, or do you see them being used more widely?
Oh, absolutely. I think within the statutory framework, I think employers are fairly comfortable with that framework now. It's a fairly simple structure, and very rarely would I see one that I think would fall outside. And also at different levels of employee, senior executives, exit discussions are framed as protected conversations in my experience, and for more junior employees as well. Ultimately, employers, I think, are pretty good at getting it right, positioning it right, and the judgment always comes down to the number, in my experience, and how you frame a deal, because that really is what focuses the minds. And if they can frame it in the right way at a number that both parties are comfortable with, then deal is done and the parties move on.
Well, thanks very much, Greg, for sharing your experience and expertise around protected conversations. I think I agree with you that protected conversations have become part of the sort of day-to-day toolkit for most employment lawyers and HR practitioners. And they're very useful in the right circumstances. Well, that's all for this particular podcast. But just a reminder, please to continue to follow us on LinkedIn, and the podcasts are available on Spotify, Apple, or where else you obtain your podcasts. Thanks very much. Well,